So we will get started, right? So yesterday, I said to some of you guys, I said, something is better than nothing, right? So verbal agreement is better than not having any agreement at all, right? But in writing, right, so the paper, actually it's a little cut off, but it should say that a contract is worth the paper it's written on, okay? And for the most part, and I think I mentioned this yesterday, we all need to understand something legally. Once someone signs something, legally, the law says you are presumed to have understood what's in the contract. Okay, and why is that important? How many times do we sign things that we don't read? I know I do, right? I checked out at my hotel this morning and they made me sign something. I'm like, I'm just in a hurry, I gotta go, right? We do it all the time, and guess what? It's not a legal defense to later in the future say, oh, but I never read it, right? I didn't see that clause, or I wasn't sure what that meant. Well, the law presumes that if you sign something, you had read it and you understood it, which is why it's important for you all as contractors to have really detailed contracts, okay, that's gonna govern your relationship with manufacturers, with distributors, with homeowners, your customers, because even if someone doesn't read something, and there's a clause there that protects you, okay, it will be legally binding if we have four things, okay? One, there is something called mutual assent, right? Two parties came together mutually and said, yes, we are going to contract with each other. Yes, you're gonna install spray foam, and yes, I'm gonna pay you for it, and I'm signing this agreement, right? Consideration means, how much? What are you giving me, okay? I'm gonna pay you money for 10 pounds of foam, right? Or, I'm gonna install foam, but you have to tell 10 friends. Doesn't just have to be money. It's someone doing something on your behalf for something that they're receiving. That's consideration. The third thing is capacity. Capacity is, can I legally enter into this contract? Okay? So if you guys have a customer and it's the day to sign the contract and the parents are not home and there's a 14-year-old at the house, and he signs that contract on behalf of the parents, is that going to be legally binding? No. The answer is probably going to be no, okay? Probably. Because in the law, a lot of things depend, right? That's the answer. But that's what capacity means. Usually someone over 18, someone who's mentally there, right? Not someone who's disabled or who's under a conservatorship, right? Those contracts, if you enter into a contract with someone that lacks capacity, it will not be enforceable. It will not be enforceable. Okay, the last thing is, which you guys don't have to worry about, legality, right? I can't just go to a drug dealer on the street, right, and sign a contract that says, I'm gonna pay you for the drugs. It's not legal, so therefore it's not enforceable and it's not binding, okay? So mutual assent, consideration, capacity, and legality, that's the legal elements of what it takes to have a binding contract, okay? So we're gonna talk about three things today: contracts, estimates, and invoices. Let's start with contracts. Who do I have contracts with, or who you should have contracts with? Manufacturers, okay? For sure, you're buying product. This is where you're getting your supplies from. You should have a contract with them. Oftentimes, you're gonna have no say-so in what that contract says whatsoever, right? It's, here it is, take it or leave it. You don't like it, go to somebody else, okay? General contractors, these are gonna be important. I spoke about this at length yesterday. You should have contracts with your general contractors in writing, okay? And we'll talk about what those contracts should say. Suppliers, same thing, with your distributors, should have contracts. What's gonna happen under this situation? Or what happens if you don't deliver on time, right? What happens to my potential profit, right? Specifically, if I tell a supplier, I need 10 drums by tomorrow. I have this big job, and obviously this is a extreme example, right? But I have this big job that the homeowner said, I want you, but it has to be this week. If not, I'm going with somebody else. Supplier says, we have it. You're good. What if they don't perform? Okay? If you have a contract, maybe you can sue them for the profits that you just lost because they went with somebody else, right? So again, we'll talk about those details. Customers, obviously, right? These are the ones that you probably all have. And employees. I know before me in this conference, or this session, I'm not sure if you all were here, there was a lawyer talking about immigration, right, with your employees. You should have contracts with your employees. If you don't, it's okay, right? Depending on the state you live in. A lot of states are what's called at will. I can fire you for whatever reason or no reason, as long as it's not discriminatory, okay? But in those states that is not at will, definitely should have an employee contract. It tells them what they can and can't do during their employment, right? And in my opinion, more importantly, it tells them that if they leave you, maybe they can't work for a competitor, okay? Maybe they can't steal the things that you taught them and take them somewhere else, okay? A caveat briefly on that one is that that's starting to change. These non-compete agreements, the Federal National Labor Relations Board is slowly heading towards that they're illegal, okay? Because you're stinging competition, but we'll talk about that. Okay, so here are the basics of what all these contracts should have. Let's talk about the first one, and I think it's the most important one, is the scope. What does the scope mean? What are you going to be doing, okay? Does anyone here have contracts that they're using currently today that has a specified scope within that contract? Yes? Okay. So, did you raise your hand, sir?
Yes.
You did. Can I pick on you for a second? All right, give me an example of sort of what you have in your contracts under the scope.
Scope, we would go in and describe exactly what we're going to do, apply spray foam to a specific area, so many square feet, specific nominal inches we're going to apply.
Okay. So just limited to what we're going to spray and where.
And when.
And when, okay? Anybody else have anything different for the scope? Anybody else? Okay, yes sir.
We put the exact manufacturers that we're using.
Okay, that's a great idea, we'll talk about that, right? But did everybody hear that? They specify in their agreement the specific manufacturer that they're using, right? So a brief little caveat on that, if you're gonna put that in your agreement, make sure you use that manufacturer, okay? In my litigation cases, right, so non-contract issues, right, so again, you can have the best contract in place and something's gonna happen, right? In 90% of my cases where I'm in court fighting for the manufacturer or for the contractor or for the supplier, okay, 90%, and in the last 10 to 15 years, I've handled about 70 cases, okay, that have gone to court. 1%, literally like 5 or 6, whatever that percentage works out to, right? The homeowners never knew what was being installed. Never. It was just, I want spray foam, okay? And something happens and they say, hey, by the way, what did you spray at my house? Okay, I'm looking online now because something happened and there's 6 or 7 manufacturers. Which one's in my house? Okay, so that's actually very important, and again, we'll talk about more details on that, okay? So yes, the scope is very important. Here's what I'm gonna do. Here's when I'm gonna do it. Depending on your customer, you may have a date of completion, right? And more importantly, in my opinion, in your scope, you should also specify what you are not going to do, okay? So the scope should not just be limited to what you are going to do. Do you have any things in your agreement that says, we will not be doing this?
We have delimiters later in the contract.
Excellent. Same thing, sir?
So one thing I also learned is, like, if we're doing certain areas, we do a lot of roofing, spray foam. I'll line out the area from satellite measurement of the area we're doing, because a lot of times 10 feet over can leak,
That's right.
Because we walk on it.
Absolutely, that's another great point, right? Here are the areas that we're gonna be spraying. Now, I will say this, and this is sort of like a tough one here for lawyers if something happens in the future, right? Writings are great, but sometimes having too many things on paper can also hurt, right? Because now, in a contract such as this gentleman's here, he says, I'm only doing this, and then all of a sudden they see something oozing out of the wall or a stud on this side, right? They go back to the contract and said, you told me you were only doing that area, right? So you clearly are in breach. Something happened here because you went above your scope, right? So if we're gonna draft it, if we're gonna put it in the contract, make sure we stick to it because it can hurt us as well, okay? Try not to exceed your scope. Any questions on scope? Okay, all right. All right, so we talked already within the scope, right? Dates. When are you gonna start? When will you finish? On the when will you finish, be careful again, right? Things can happen. So what I would like to see, and when I draft some of these contracts, I do a little footnote or in parentheses, depending on weather, supply issues, okay? Depending on you, the homeowner, right? Because what if they're all of a sudden they show up and you had told them before they can't be there during the spray process? You gotta stop, right? Hopefully. I'm telling you right now, you should stop, right? Legally, you should stop. But anyways, that should be in there. And more importantly, what has to happen before we start, right? Because if you have a start date of Wednesday, March 6th, okay, at 3 p.m., and you show up, and that job site is not ready, okay, you technically now are in breach. But if that job site wasn't ready because something the homeowner did, right, you're fine. You're good. You should put that in the contract. And by the way, I know there's a lot of bullet points here, and you guys are probably thinking about a 10-page contract. Not at all, okay? The way I draft these things, they're not very small print either, right? But you can get these in 1 or 2 pages. How big are your contracts, sir?
2, they may go over for a signature line on the 3rd page.
On the 3rd page,
Yeah,
right?
exactly.
Anybody here have a contract that's over 5 pages? Okay? Customers sign them anyways? They said yes, right? Again, sometimes they see so many pages, like, all right, I'm just signing it, and you have this stuff in there. So when it comes to the business aspect of it, right, which I know nothing about, that's up to you guys. Man, I don't know if a customer's gonna get scared with so many pages in a document, but I can tell you that I'd rather have 1 extra page with 6 or 7 of these things that are on here to protect you guys than not having that, okay? Okay. Sort of bleeds into the obligations, right? Specify, here's what I need you to do as a homeowner. If the homeowner is going to be responsible for removing the old foam, or excuse me, the old insulation, right? Then put it in the contract, okay? If the homeowner, I guarantee I'm going to have half of the room raise their hands here. How many homeowners do you guys have that says, by the way, I'm going to handle this so I can save some money, right? I'm going to do this. Put it in the contract. If it's not in your sort of boilerplate contracts, then handwrite it in, right? And initial it. And have the homeowner initial it. Why do we do the initials? Because that way they can't say, oh, you put this in there after I signed it. Okay? So have them initial, put a date on it. I know it's a terrible thing to do, right? It's like, but we can't trust anybody. That's my job. I don't trust anybody when it comes to these cases. Okay? All right, now, I spoke a lot about this yesterday, and this is called indemnification, okay? Indemnification basically means I am going to protect myself in case somebody else does something wrong, okay? So, this comes into play in your contracts with general contractors or with other trades if you're helping them or they're going to be in there or if there's any reason for you to contract with them, right? So the GC calls you and says, hey, I want you to install some foam, okay? Maybe they have their own agreement. Maybe they don't. Okay, but you're going to have yours, hopefully. And with your agreement with the general contractor, you're going to say, by the way, if something were to happen, that the homeowner sues me for something you caused, you are going to pay not just my attorney's fees when I hire an attorney to defend myself and my company, right? But also, if I get held or be liable for having to pay damages to the homeowner, you have to cover it. Okay? So imagine, all right, if a lawsuit, you get served, you read it, what is this? I did everything right, I have my contract, okay? I put my warning signs up, I told them to get out of the house, but the general contractor one day when I was gone told the homeowners, you can come back in, we're good, right? I guarantee you, there's not a single lawyer in this country that is also not going to sue you. That's their job, okay? And guess what? You look back at your contract, and you're like, wow, I have an indemnification agreement or an indemnification clause, okay? And that's going to protect you because in that case, where by the way, you call the lawyer and you say, hey, by the way, it wasn't my fault, it was general contractor, okay? How many times do you think that lawyer's going to say, thank you for letting me know, you're off the lawsuit? Never going to happen, right? So it may happen in a year or 2 years where you're finally out of this case, 3, 4, 5. I have a case right now that's been pending for 7 years. 7 years, okay? And we're talking about a lot of money in attorney's fees for something the spray foam contractor did not do. Yes, ma'am. No, she's done. And they're not worried about it because they're not paying for it, right? So in these indemnification clauses, you want a couple things in there, right? You want a notification provision, all right? How are you or the other person going to notify you if you want indemnification? That's very important because if you're going to exercise your right to that, you got to give the other side notice. Hey, by the way, I got sued. It was your fault. I'm putting you on notice. Come defend me. Okay? Also, there's now, in a lot of contracts back in the days, they didn't have these, but they're called advances. I'm not going to wait, right? I'm going to pay money to my lawyer, and then you're going to reimburse me. Do you want to trust that, right? So put an advance. If I get sued, you have to front my costs. You have to front X amount, whatever the case may be. That should be an indemnification clause, okay? What I will say lastly on this, if for whatever reason you don't have this in your contracts, it is still available to you under what's called common law, okay? I mean, just the law, that's just the way it is. But it only applies if you're completely without fault. Completely without fault, right? And the only way you're gonna know if you're completely without fault usually is at the end of a lawsuit after a trial when that happens, okay? Any questions on indemnification? You guys back there that have these big contracts, do you guys have indemnification provisions? Do you know? Don't have it or you don't know? Don't have it, right? So I think now you're not a 6-page, right? Sure. Yeah, with a homeowner is an interesting one, right? So with a homeowner, the way I can see that sort of playing in is if they bring trades in, okay? Or somebody sues them, or you get sued. I'm trying to think, that's a good one, right?
But we don't do contracts with the general contractors, so you got anything.
Okay.
Well, I wanna put it in there because of homeowners. Homeowners, when they generate their own project, they don't know what's going on. We're being sued, we worked on a house that burned down. They're suing everybody that worked on the house.
Absolutely.
So I wish I had that in there.
Right. Or what if something happens where the general contractor sues you for something the homeowner did? Right? So let's say, I don't think that any of my clients, contractors, ever leave their equipment on site, like overnight. Let's assume you did. Put it in the corner. Homeowners don't listen to your advice. They come back in, they move your hose, they're playing with it, right? They're like, oh, this is cool. And they leave it hanging out. General contractor has a tradesman go in the next day, and they trip over that hose. Did you do it? No, they're gonna sue you. Now the homeowner has to indemnify you for something they caused, right? Okay? Be careful if you're drafting these, and if you're looking on Google for these, because a lot of states will not, and it's just not allowed, will not allow you to indemnify willful conduct, okay? You can't say, well, you indemnified me, I'm gonna just go crazy on this thing, but you have to cover my fees. It doesn't work that way, right? And if you don't do these clauses correctly, or if you don't have somebody who's doing them correctly, the entire thing can be invalidated if only one issue arises, okay? All right, now, another very important one in my opinion, for homeowners, and I guarantee you, nobody has this, so if I'm wrong, call me out right now, please. It's called assumption of risk, okay? Anyone done like an excursion, taking a jet ski ride, gone bungee jumping, skydive, right? Before you do it, you have to sign away your entire rights, saying, you know this is dangerous, you know this is risky, and you're doing it anyways, so if you die, you can't sue me, or your family can't sue me, okay? If you get hurt, you can't sue me. I told you this is dangerous, right? I told you there's a chance you may get hurt. Same thing with surgeries at hospitals and doctors, right? I'm gonna cut you open. Something can happen when you're under the knife. You cannot sue me, okay? That is huge in these cases. Imagine your contract that says, Mr. and Mrs. Homeowner, I'm installing foam. And by the way, think about this, right? You're probably thinking, well, I don't want to scare the homeowners. But the A side of the foam is a toxic chemical, okay? The B side resin part of the foam is a toxic chemical. When you mix these things together, there's a chemical reaction happening right? Which there's fumes and exhaust, right? That is toxic to breathe, which is why we wear masks and respirators, okay? So I don't think you're gonna scare a homeowner, in my opinion. Anyone scared about that you're scaring a homeowner if you tell them, by the way, Mr. and Mrs. Homeowner, I'm installing toxic chemicals in your house. There is a chance that you'll get an odor. There is a chance that you may not like the way you feel after, let's assume, right? And again, I'm not telling you to specifically say this, but something along those lines. And by signing this document, you are aware of this, you are confirming that I told you about it, okay? And you're not gonna sue me if anything happens. Anyone scared to put that in their contracts? No? Okay, that's good. Because this to me is the tough one, right? 99.9% of the cases that I get litigation-wise, it's a homeowner saying, the contractor never told me to stay out. I had no idea what was being installed in my house. I had no idea this was toxic. I had no idea that it could smell like X or Y and Z, right? Usually, all of my cases, it's rotten eggs, or like a sulfur type of thing. I don't know how that happens. I had no idea this happened, okay? You know how many times I wish I had a contract? I'm like, oh, well, that's interesting. You signed the document that says you did. And what happens in the law if you sign something? It's presumed that you have read and understood it, right? So they can't now come into court and say, I had no idea. Because if you don't have this clause, your argument is going to be, Alex, I told them. Do you have anything in writing? No. Did you record that conversation? No. Did you have any witnesses around you when you told them? No. So now it's he said, she said in court. And that's it. That's the only issue I'm fighting in court. I'm hoping that the jury believes us and not the homeowners, right? And the homeowners are going to have 4 little kids, and they're homeless now. Who do you think the jury's going to want to side with? Right? So this is a big one. This is the big one. Does anyone have this on their contracts? Anything like this? No? Put it in there. Okay? Doesn't have to be all scary. I have told you that the vacation period or the time period you have to be out of the house is 24 to 72 hours, depending on the manufacturer, right? And back there, he specifies who the manufacturer is. I acknowledge this. Check. I told them. I don't have to rely now on my memory 4 years ago, because these cases sometimes pop up 4 years later. Okay? All right, now, force majeure is another important clause. Force majeure basically means an act of God, right? You breached your agreement because you didn't show up. Why didn't you show up? Because there's a huge earthquake and nobody could move, right? Or I didn't show up because the government shut down everything during COVID. This is when this really started happening for lawyers, was after COVID, okay? And a lot of people did not have force majeure clauses. And even the force majeure clauses that they did have did not include government shutdowns. Every single contract now includes specifically government mandated shutdowns, okay? For you guys, weather, okay? In this specific industry, maybe not extreme weather, maybe cold temperatures that you guys don't feel right with on substrate, right? Maybe internal substrate temperatures, okay? Put that in there. Put that in there maybe, okay? Again, this is all to you guys and how much more you want to put in there, but again, the more, the better. All right? Okay, disclaimers. Obviously, we have warranties, right? You guys warranty your work, maybe, you don't. But if you do, tell me what you don't warrant. Okay, you guys have probably seen these in other products, right? I warrant my product if you use it correctly, okay? I warrant my product in foam if you don't cut into it on your own, right? Once you cut into it, it's not under warranty, even if it's by mistake. If maybe it's an application where it's not closed, right, and there's UV light coming in, and that's going to damage the color of the foam, I don't warrant that, right? So think about all these situations that perhaps could happen in your industry, right? If you guys are newer to the industry, reach out, right? This is why we're here. We're here to learn from each other, and we can share with one another, hey, this happens. Put that in there, okay? Okay, dispute resolution. This, for me, also very important. Let's assume you're gonna get sued, okay? Whether it's a really serious issue, like the foam was installed improperly, right? The foam is off-gassing, or just a basic issue where it's like, hey, by the way, they still owe me $500 from that contract, okay? So remember, this is also to benefit you when it's your turn to sue somebody, if you have to. Dispute resolution clause is basically where do you want to sue or where do you want to be sued, okay? And not just location, but where, what court. Maybe the one down the street of my house. Convenient, right? But specifically, this situation is really important for those of you who sort of work in 3 different states, right? I had a case, and you guys who were here yesterday heard the story, in Libby, Montana, where the general contractor was from Idaho and the spray foam contractor was from Washington State. But to get to that Libby, Montana was a couple hours, right? So now the Washington State contractor was sued in Libby, Montana, in a very, very small town. That everyone in that jury, when they filed the lawsuit, knew the homeowner. And they're going to want to pull for the homeowner. And they're going to say, who are these people from Washington? We don't care about them. Guilty, right? So think about that. Where do you want to be sued? Where, what specific courthouse, federal court, state court? Or do you even want to go to court? Maybe arbitration, right? Which is more confidential, right? Anybody right now can, a customer, you guys got an invoice or an estimate, and they look you up. And maybe a lawsuit that you had pops up, right? Now that they're scared. If it's arbitration, they'll never find it. Okay? They'll never find it because it's very difficult to find those filings. Maybe you want to sort of have a negotiation before anyone can file a lawsuit. Yes, you can put that in a contract. Before you sue me, we have to sit down and have a good faith negotiation with a mediator, a third party neutral, a former judge. You can put that in the contract. Yes, sir.
Question, so like I've been through a couple cases due to lack of verbiage in our contracts and stuff like that, and like we got the ROC involved, you know, so that would be like what you're talking about.
Like a mediator?
Yep,
And did it work out?
yep,
It saves you a lot of money, right?
yep.
Right? So that's a great clause. It saves you a lot of money. Okay? Once you file a lawsuit, companies cannot defend themselves. What does that mean? Oh, I'll do it. I'll handle it. Can't do it. If you're an individual, you can defend yourself. But a company has to hire a lawyer. Who writes the laws, guys? Lawyers, right? No. That's why we do it. We want to get hired. But companies have to hire a lawyer. So already, just to respond to a demand letter or just a negotiation, you're spending money on lawyers. Don't do it. Just don't do it. Put it in the contract. We have to sit down, we have to negotiate. I had a case in Lancaster, Pennsylvania. And it was in a region which is very religious. I believe that they're Mennonites. Okay? And the people who work there have in their contracts that before a dispute happens, they have to sit down with a community church member. That's how they handle disputes. I learned that. Really interesting. But it was in their contract. We have to sit down with the bishop of this, and unfortunately they didn't resolve it, but it was in the contract. Okay, so that's a really interesting one. All right, insurance. If you can do this, especially with the GCs, maybe even with the homeowner. I've never seen the homeowner situation. If the other party who's hiring you has insurance, maybe tell them you have to add me as a beneficiary. Okay? Has that request ever been requested from you guys? Right? So turn it around on them as well. Maybe it works, maybe it doesn't, right? Maybe you're gonna have some people who are gonna see your contract and say, no, I don't agree to this. And they're gonna scratch it off and initial, right? But at least it's there. So start thinking that way. Hey, put me on your insurance. And by the way, you should have your own insurance. We talked about that yesterday. But have them put you under insurance. I'll finish this section with the fact that, like I mentioned earlier, sometimes you guys are going to be completely powerless to change any of the contracts that are presented to you, maybe by the general contractor, by the manufacturer or distributor. Okay? Maybe. Try. I have seen in very rare situations really big national players in the distribution market change their terms and conditions for specific customers. Try it. Okay?
Whose contract is enforceable? Because we have our contract, obviously, at the end of our estimate and whatnot, but then when you're working for larger companies, they have a contract. We're going to hire you to the terms. Who's are more enforceable, I guess?
It depends, right? It depends on what situation. It depends on what your contract has and what their contract may not have, right? It all depends. That's an interesting one. Usually you're not going to have that situation where you're going to have a GC sign your contract and they're going to make you sign their contract. Not going to happen. It should only be one contract, okay? Because then you get into the battle of the meeting of the minds, right? So let's go back to the mutual assent element. how can, as a lawyer, I argue that I mutually assent to two different things? Okay? So that's a sort of a situation where a court can say, I'm invalidating both. Okay? Mutual assent is, what were we thinking when we entered into this relationship? Perhaps also which one was executed after, the most recent one. Maybe I can make an argument saying we had our first agreement, but then by entering into the second one, we got rid of the first one and we ratified this new agreement because it was later in time. Right? That's how I make my money, is taking these sort of arguments and just presenting them, right, in these situations. But in my opinion, it's just better to have one, okay, with one party. Now, you can have one with the general contractor and one with the homeowner, okay? You can also sometimes, and I'll talk about this when it comes to estimates, right? You can also sometimes have a clause that says, and actually a lot of contracts have this, which is, this is the only agreement we have. Okay, have you guys seen that in a contract? Probably not, because it's deep in there towards the end, right? It basically means this is the only agreement we have, okay? So if you said something after, I'll help you out, don't worry, I'll charge you less, and it's not in writing, guess what that contract says? This is the only agreement we have. If you guys came to some terms before you signed this contract, and it's not in there, this is the only agreement we have, okay? The other thing you can do is to say, if there are any future agreements, or if there are any agreements that are inconsistent with one another, this one supersedes it. This one controls. This one governs, okay? Any questions on contracts before we move on to estimates? No? Okay. All right, so estimates, in my opinion, are very, very easy to handle, okay? Except in the situation where you have a bigger contract, okay? So obviously an estimate, this is a sort of a business comment, is estimate the best estimate, right? If you're gonna estimate, make sure you're in that range, don't sell yourself short. Now, if all you have is an estimate, if that's all you have, and I've seen that, I have clients, I'm like, show me your contracts, and all they show me is an estimate. I'm like, ugh, right? This is not a contract. Unless all costs are final and guaranteed, okay? Bound by the estimate, and both parties have to sign the estimate. I've never seen an estimate signed by both parties. Only usually one, the homeowner. Okay? So if
You have to do it. If you get sued, can you just go sign your own estimate?
I didn't hear that. Right? I'm serious. And then when you're in a lawsuit, there's a process called discovery, which basically gives the other attorney, and your attorney as well, the right to ask for any and all documents relating to the issue. And when I do that, and I ask the homeowner, give me all the documents that you have related to this transaction, I'm gonna find one with only one signature. And you're gonna have one with two signatures. We have some explaining to do now, right? So, right? I didn't hear that. But yes, but if all you have is an estimate, make sure both parties sign it. Make sure both parties sign it. If all you have is an estimate, okay? Now, if all you have is an estimate, try to put as many things as possible in that estimate, okay? What I like to see, again, talked about all the things we talked about, right? Clearly define that it's just an estimate, and it will be or may be subject to a more detailed agreement. That's what I like to see. All right, an estimate is just an estimate. I'm estimating for you, okay? Usually done for the purpose of them taking it, talking to other people, and coming to a decision of who they're gonna hire. But if you're gonna decide to hire me, you now know we have to enter into a brand new agreement, a more detailed agreement, okay? So if that's your intention, if all you want to give them is a one-pager just to feel them out before they fully decide to commit to you, put it in the estimate. If we enter into this relationship, you will be signing a more detailed agreement, which is going to completely cover you, right? What we talked about, all those terms and conditions, going to be a little bit more hefty. Okay? Yes, sir.
What if you don't have that?
If you don't have that, and all you have is an estimate, whatever the estimate says is what's in control.
No, but if you don't have that on your estimate,
Right, perfect. No, you don't have to. I like it because they expect it, okay? And also, you remember also to make sure you get this thing signed, right? I have a lot of people who have contracts in place and they don't get them signed. Oh, I forgot to get it signed. Me as a lawyer, I have retainer agreements, and sometimes I forget to get them signed because it's a client I had known for a while, right? And I'm like, oh, they're good for it, okay? But that again goes to your question, sir, right? So if you have an estimate signed by both parties, and it doesn't say that language, but then you guys enter into the more hefty agreement, guess what that agreement is going to say? This is the only agreement we have. This is the only one that controls. So if there's anything different, specifically when it comes to price, that's higher in the main agreement than the estimate, which one controls the main agreement? Okay? Yes, sir.
Sorry, I have a question. So in our contracts, we have like additional work, we'll have additional costs for unforeseen substrate, so on and so forth. And a lot of times you have change orders in all your contracts because they want more this or spawning areas or whatever the case may be. Like if we end up replacing a bunch of more stuff, do we have to have them sign a change order, or does our contract that they sign?
Let's go to the elements. Right? So the answer is you don't have to. You don't have to. Because without that contract, without that change order, this is what's going to happen. Hey, I want now more foam in this corner. Okay, perfect. That's going to cost you X more. Okay? And you do it. And they pay you. Done, right? Or you do it, and then they say, oh, you know what, come to think of it, I don't like that anymore. Right? And now you sue them. Hey, you owe me this. You told me you wanted this. Show me where it is in writing. It's just your word against them. Right? So, if you don't have it in writing, do you have a mutual assent? Right? Yes. He told me he wanted more foam. I said, okay, I got it. Was there consideration? You probably told them it's going to cost you X. They agreed. Right? Consideration doesn't have to be fully paid. It's an agreement. Right? And was there capacity? And was legality. Right? So, but, right, the point being here is the main point of this presentation is protect yourselves. Get it in writing. Yes, sir.
As far as in writing, does it count if it's in an email thread? I mean, that's usually what we try to get.
Anything. Something is better than nothing. So we had, yes, sir.
So does the estimate have to be a separate form as the contract proposal, or can you have the contract proposal with the estimate clause on it?
Absolutely.
So you can just take that off and finish it up and
Yep.
get it signed. You
You could do that as well, right? As long as what's the main document that's going to govern your relationship? Is it going to be the estimate or the main document? Right? Make that clear. The same way that I said, a lot of agreements have this is the only agreement. You can also have a clause that say this agreement incorporates any and all other agreements we entered into. You can write that as well, right? This is why sometimes, I'm not just saying this to be self-serving, this is why sometimes just going to Google and copying and pasting clauses is a really bad idea. Okay? Any other questions before we move on? I think I saw another hand. No? Okay. So again, so an estimate, right? It's a simple sort of one-pager. It could be a formal agreement. It could be a formal agreement, but let's be clear. Okay, let's be clear. That's an example of a disclaimer I like to put in estimates, right? It's not the only agreement between the parties, and any additional agreements executed by and between the parties will govern, right? Just like that, that can have very different variations. Or any additional, no, this controls, right? And that's estimates, okay? We're running low on time here, so I'm going to move on to invoices. This one obviously comes after the fact, okay? So, how do we protect ourselves with invoices? I like when there's a clear date of payment. Hey, net 15, net 30, okay? And method. How are you going to make the payment? Credit card. If it's a credit card, do you have something in writing that says you're going to pass on the processing fee? If you don't, there's no meeting of the minds. There's no meeting of the minds, right? Because the homeowner's going to say, he never told me that. Now you're stuck, okay? What's going to happen if they don't make payment on time? Have that in the invoice or in the main agreement, okay? Because the main agreement is going to control. The invoice is just a reminder, hey, I'm done, here it is, right? What's going to happen if they're late? Is there going to be a penalty? Is there going to be a fee, right? Reinforcing clauses in the more robust agreement, you can do that very easily. Just say, hey, the same terms and conditions found in the agreement that we executed apply to this invoice. That's it. Super simple. One sentence. Okay? I like nowadays especially, there are ways to send invoices via email or platforms that will tell you when your customer opened that email or saw the invoice and when they clicked on it or something like that. Because how many customers, I never got that invoice. Yeah, okay. Here's an email that says you opened it on this day, right? Depending on your jurisdiction, on your state, lien language. What happens if you don't pay? I can put a lien on your house, okay? And do you have to sign the invoice? I put a question mark. It's better than nothing, right? I don't think you have to, but it's great if they signed it. Why? Because that confirms they received it. That confirms that they know what they're getting into, right? And it's, again, better than nothing. Real quickly, let's talk about other writings. Real quickly. Other writings during the job, right? I love acknowledgments, whether that's going to be in the main agreement or not. Hey, I acknowledge that this was happening. I acknowledge this, right? I think the question and the main purpose of the slide is what you said, sir. Can it be an email? Can it be in a text, right? Communicate in writing. Hey, by the way, I'm so happy that you are happy with our work. Unsolicited. Maybe they just said it. By the way, I loved your work. Put that in a text message. Oh, by the way, thank you for your compliment. Okay? Thank you for telling me that my guys were very professional. Thank you for doing this. By the way, we left today and this happened. Hey, I'm taking down the signs. Everything is good. Some writings, because if you find yourself in a lawsuit later, writings are amazing. Because again, it's 4 years later that the lawsuit can sometimes come. You're not going to remember any of that stuff. But if you have a writing, you can definitely remember. Okay? Same thing, right? I just talked about the post-installation affirmations, right? Thank you for this, thank you for that. Remember we did this, remember you told me this. It sounds laborious, right? It's like, man, I really have to worry about this stuff so much. But it makes a difference, it really does. And again, as you can clearly see, that assumption of risk clause is important in my opinion. Okay, very crucial and very critical. All right, so that's it for me, guys. If you have any questions, let me know. I'm gonna stick around for a couple of minutes. I have a plane to catch. But yes, sir, go ahead.